What's up, everybody? Welcome back to the Homie Hangout, where we help others move in excellence. And I've been getting a ton of calls and messages and people asking me about this recent Ninth Circuit Court of Appeals decision in which an individual from Southern California who had a history of nonviolent felonies was given a case by the feds for possession of a firearm, felon in possession. And basically, the Ninth Circuit Court of Appeals says, man, we don't know that we can do that anymore, right? And so people are wondering, hey, how do I get my rights back? What do I got to do? And so I just want everybody pump the brakes for a second. And I'm going to run through kind of where we are, right? To do that, we have to see how we got here. And I'm not talking about going back hundreds of years, but just a couple court cases in the last, 20 years or so that sort of set us up for where we are. And I think then you can sort of see where we're going as a nation when it comes to this. Okay. This is not my first time doing this video. I've had to take a lot of elements of it down because of YouTube censor. So this is kind of the best I can do. And some of the language might be a little childish and some of the little PowerPoints, but it's kind of the nature of where we are today, right? So the first decision to look at, right, is Heller. U.S. versus Heller, 2008. It was a 5-4 Supreme Court decision. Heller is a law enforcement officer who lives in Washington, D.C., okay? And he's allowed to carry a handheld. In fact, he's required to for his job in federal buildings and all kinds of places that your average Joe can't do that. But he's not allowed to have one at home. He applied for a permit. He was denied. Nobody has been approved since 1975 when Washington, D.C. effectively banned hand toys, period. They said in order to have one, you need to have a permit. But they didn't give any permits since 75. So there's not many of them out there legally. And then also said for long arms, you need to have trigger locks or they need to be disassembled. They need to be in gun safes, like tons of restrictions, even on what that looks like inside your home. Okay. So he appealed and was like, hey, this is ridiculous. I live in the hood, right? It didn't used to be the hood, but now it's the hood. And this big old, long arm thing that I have is just kind of goofy and awkward. I want a handheld. Okay. And he was told no, right? Obviously. All the courts had said no. So the Supreme Court finally picked it up. And they looked at specifically the question of, does that ban violate the Second Amendment rights of individuals who are not affiliated with any state regulated militia, but wish to keep hand toys and other arms for private use in their homes, right? And it's the first time since like 1939 that the U.S. Supreme Court directly addressed the Second Amendment. And the court said the law is unconstitutional. Okay. That is a right that doesn't need to be connected to having a militia, right? It's a self-defense and a protection thing. But that right is not unlimited. The court was very careful back then and said that doesn't mean anybody can have any kind of weapon anywhere they want at any time. And they used examples of like schools being safe zones and felons and mentally ill and unusual weapons as stuff that it really wasn't addressing. It said, look, we're not talking about any of this. We're talking about what we all think of when we think of arms. And that stuff is legit, right? So that was controversial at the time. And it led to this other law or this other case, McDonald versus Chicago. Because Washington, D.C. is not a state, right? It's this little federal, it's this weird thing, right? I don't want to get into it and make a different video, but it's not a state. So other courts were saying, well, hey, that doesn't apply to us because we're a state. And as a state, we're allowed to make these kinds of rules, right? So in comes McDonald versus Chicago, right? McDonald's like 70-some years old, owns a house in the Morgan Park area since 1971, which I think is kind of a suburb. But he's like, man, it used to be a cool neighborhood. Now the whole hood has gone to hell, right? And similar situation, he had, I think I'm far enough through the censors to be able to use these words. He had a shotgun for home protection, right? Which was legal. But he wanted a banger. He wanted a handheld one. And again, Chicago since 1982 had not given out a permit for a handgun, right? They effectively had banned them. And so he's like, I can't defend myself, without being able to have a firearm, right? And what the court said was that the Heller decision that we just mentioned does apply to the states, right? Because individual self-defense is a central part of the Second Amendment, okay? And the 14th Amendment, right? I put it 14A here, but the 14th Amendment has this whole due process clause that basically says, hey, certain rights of citizenship for, folks in the United States, Americans, um, they hold those regardless, and states can't step on those rights without some level of due process, right? So that was a huge decision, okay? And then it leads to, this is one of the goofiest ones, but simplest ones to understand. Caetano versus State of Massachusetts, right, in 2016. This was an incredibly rare 9-0 Supreme Court decision. Okay, so you already know. And like I put at the bottom, the court basically said that Massachusetts was stupid. So Caetano, right, Jamie Caetano, had this violent ex-boyfriend. She had been put in the hospital by him. She got restraining orders against him, but he still kept pushing the issue. He'd run up on her places, go to her workplace, all this other stuff, right? And obviously the restraining order wasn't working because the dude was a JCat, right? Her friend gives her a stun gun and says, hey, try this. So one night she's coming out of work. This fool jumps out and accosts her, right? And she pulls the stun gun and it worked. She didn't even use it. She just pulled it and he was like, oh, snap, hold on, and backed up. When the cops come, I wasn't able to figure out if the cops arrested the ex, right? The stalker dude. I wouldn't be surprised, honestly, if they didn't. But they did arrest her. And they arrested her for brandishing it. And they said, hey, Supreme Court, she wanted, going to court. She went to trial. She pled not guilty. She got found guilty, the whole 9 yards. And the Supreme Court said, hey, laws around guns don't really apply because there was no such thing as stun guns back in the 1700s and the 1800s, right? So they don't count as, bearable arms, right? To which, again, the U.S. Supreme Court in a 9-0 decision basically said, what the fuck are you guys talking about, man? And here's some memorable quotes, right? Some important quotes. So, bearable arms, right? The decision defines this. Bearable arms are anything someone wears for defense or carries or takes into their hands for offensive or defensive action, whether or not it existed at the time of the Second Amendment and whether or not they have any military use. Because that's also been an argument, right? Is militia means military, is different, blah, blah, blah. And then there's a quote, I believe it's from Alito, Supreme Court Justice Alito. If the fundamental right of self-defense does not protect Caetano, then the safety of all Americans is left to the mercy of state authorities who may be more concerned about disarming people than about keeping them safe. And I know that is a sentiment that is felt strongly by a lot of Second Amendment advocates, right? Basically that kind of sums up their, a big part of their belief system. And so the courts are agreeing, right? And I don't know, I would say personally that I agree with this as well. So then what happens from there, right? The two-step. There became a two-step thing because lower courts then had a lot of questions, right? The question, Chicago answered the question about, do these laws apply to the states, right? And Chicago said, yes, they do. Okay. Do they apply to stuff other than traditional arms? Yeah, kind of, at least when it comes to stun guns. But how do we let the states still regulate gun use? Because in all of these cases, the Supreme Court has said what we are not saying is that there's no room to restrict people's right to bear arms, right? There are situations where it's called for, but they haven't really spelled out how to decide that. So the lower courts kind of scrambled. And what they came up with is kind of this two-step evaluation, right? This two-step rule. Historical meaning, right? That's step number one. Does this law that's being challenged burden some type of protected conduct, right? If it doesn't, then that's fine. Then the law is good. If it does, then there's this intermediate scrutiny, right? You got strict scrutiny, intermediate scrutiny. I don't want to get into a bunch of like legalese stuff. I don't feel like folks are necessarily interested in that. But the intermediate scrutiny basically says laws can be made that do burden protected conduct if it's important to further a legitimate government interest, right? And so that's the test they would use, which then allowed states to uphold all kinds of gun regulation laws because the states turned around and said, we have an interest in promoting uh, our own values and safety and whatnot. So we don't want guns in schools, or we don't want this, or we don't want that. And it's our job as a state government to do that, right? Obviously, folks that have kind of been pushing for a more historical interpretation of the Second Amendment are not fans of that, right? They're like, no, that's the whole problem to begin with, right? Um, so then here comes this other case, okay? New York, which is really New York State Rifle and Pistol Association, but I wasn't going to write all that, so it just says New York Guns versus Bruen. Now, Bruen is not anybody. Bruen is the head of the New York State Police. When this was first filed, it was under a different name. That dude lost his job, other people. So Bruen is not a defendant in this. The defendants in this are a couple of dudes in New York who are like, hey, man, the area is violent. Folks be getting robbed. All kinds of stuff happens, and we want concealed carry, right? Now, it's worth noting, I guess, that in all these cases so far, except for Caetano, right, except the stun gun case, but all the other ones, these are cherry picked cases, right? And all parties, do this, right? Republicans, Democrats, everybody have different interests. Um, they see a law they don't like, and then they hunt for people because somebody has to sue, right? You can't sue because you don't like a law. You have to show that you have some standing, right? You have to live in the region, or the court has to have jurisdiction. You have to have been harmed in some way. In that first case, in the Heller case, they had 6 or 7 people that initially did that lawsuit. And the court turned around and said the only one that really has standing is Heller, because Heller actually applied for the permit and got denied, right? That's what gave him grounds to sue. So all of these cases are cherry picked, and folks find people of different demographics: black folks, white folks, raza, young, old, this and that, to kind of push back. So this is no different. Again, it's not unusual. I don't say that as a criticism. It's just how our system works. So there's a couple guys, they wanted a concealed carry permit in New York because they said New York was rough. They were told no because everybody in New York gets told no based on the Sullivan Act, right, of 1911. So this law has been in place since 1911. And the Sullivan Act says that you must demonstrate a special need for self-protection distinguishable from that of the general community or of persons in the same profession, right? So people would get concealed carry permits, but they would need to meet that criteria, right? And it became this thing of the state may issue or the state shall issue, right? And it's not as complicated as it sounds. Uh, may issue is, hey, here's a list of boxes that you need to check, right? Such as demonstrating that special need, and so that you have to pay a fee and pass a background check, and so you know how to use a gun, whatever it is. Different states got different rules, right? And if you check all these boxes, we might give you a permit. We might not, right? The Supreme Court said, no, that don't fly, right? Now, shall issue laws are acceptable. Shall issue ones say, if you check all these boxes, we will give it to you, right? So states are allowed to restrict and require permits for people to have to have firearms outside of their home, or to have a concealed carry or that kind of stuff. That's why you don't need permits though for rifles and shotguns inside your home, right? Or even actually pistols inside your home, because you have a right to protect your house. Some of these other laws, then, cases were like, hey, what about outside your house? Which is still a pretty big question for the Supreme Court. But what they said is, yes, you can have permits, you can do all that, but it has to be a set of rules, and those rules have to apply to everybody. And if people check those boxes, then you have to let them do it. It's not up to your discretion. Like, oh, what do you think? Fuck how you feel. If you do these things, you get one, and if you don't do these things, you don't. And that's kind of where that court went. But also, what was done in that court, here we go, is um Clarence Thomas, right? So he turned around and this is the first time that a case, look at the numbers again. This is the first time that a case was looked at when the 6-0 or six conservatives on the court, right? So now you're seeing 6-3 instead of 5-4. These are the six very conservative justices that folks really expect to make some waves in terms of laws, right? And where you fall kind of politically depends on how you feel about that. Um, but so regardless, so this is the first time that they looked at it with the six conservative judges, and of course all six, signed on. And so um Thomas, right, Clarence Thomas says that two-step test that I just talked about, right, of historical stuff and then the intermediate scrutiny, he's like, nah, that shit don't fly. I don't like your guys' tests. I'm gonna throw it out. And now what we're gonna do is use this text and history test, right? And so, quoting, when the Second Amendment's plain text covers an individual's conduct, here the right to bear arms, the Constitution presumptively protects. In other words, by default, the Constitution protects that conduct. The government then must justify its regulations, right? If the government wants to restrict that, they need to justify that by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. Okay. And that's a big issue. That is what got us, that shift is huge, right? It has to be consistent with the nation's historical tradition of firearm regulation. Okay. You can't invent new shit. Only then may a court conclude that the individual's conduct falls outside the Second Amendment's qualified command. Okay. So, let me screen over here. Right. Here comes U.S. versus Rahimi. Okay. Now, in the meantime, between this moment in 2022, right, a lot of state courts are still upholding, state bans on different things, right? So Illinois has a ban on several what they call high-powered weapons, right? And they're saying, well, there's a distinction between weapons designed for military use and those for personal use. I think the Supreme Court, if they choose to hear that, is probably going to tell them go to hell, right? Because they basically said that already about that subject. The other thing to keep in mind, just as a process thing, just because somebody wants to go before the Supreme Court does not mean that the Supreme Court will let them. Okay. The Supreme Court picks and chooses what they want to hear. And they do that for a lot of different reasons. And some of it is political. Some of it is to give the lower courts a chance to hear more cases and try to see what they're coming up with, right? Try to see, okay, where did we not be clear enough and that kind of stuff. So not all these state cases are going to go before the Supreme Court. They also tend to pick cases where it sticks to what it is they want to talk about, right? But anyway, so Illinois has that ban in place. Hawaii still says that you need a permit to carry a gun in public. It's just that permit process is now equal for everybody, right? The standards are the same. Pennsylvania still restricts where guns can be used. And they say, well, there's a historical tradition of states making laws to regulate based on their own social problems. And in this time, there's been tons and tons of cases. Now, the Supreme Court still, in the sense of this last decision, Thomas also said sensitive areas are still probably a legitimate thing, but you need to limit them. So in other words, a school could be considered maybe a gun-free area, right? A sensitive area. But you can't just identify an urban area, right? You can't just say, oh, well, everybody downtown is a gun-free zone. No, you got to be more specific. And again, it has to align with the tradition of firearm regulation. So in comes U.S. versus Rahimi. Okay. Now this case, reading about it really bothered me, personally. So Rahimi is just a jerk, man. And there's other more colorful words for him, but basically he's a dude from Arlington, Texas. He's harassing his old lady, right? Ex now, but still, not in his mind. He's harassing her, bullying her, abusing her physically, right? He catches her in a parking lot somewhere, reaches in her car, grabbing her by her wrist, basically beating up on her. There's an onlooker over there in the parking lot, like, hey, fool, calm down. He winds up pulling a pistol, shooting at the onlooker, doesn't hurt him, then tells her, if you tell anybody, I'm gonna knock your head off. She goes and gets a restraining order. Again, not respecting the restraining order. So kind of similar to the Caetano case, and similar to what unfortunately tons of women go through all the time, every day in this country. Um, but not respecting the restraining order, not doing nothing else, and still abusing her. He winds up picking up an assault with a deadly weapon case for threatening another lady with a firearm. Like he's a weirdo, man. He's a J-Cat. But when she gets the restraining order, um, under federal law or under, Texas law, he wasn't allowed then to possess any firearms because there was a domestic violence based protection order. That did not stop him from being involved in 5 shootings in like a few weeks in 2022. So eventually he gets picked up for the assault with a deadly weapon. The cops go and search his house. They find that he has two pow pows, right? He's got 2 rifles there, guns there. And they sentence him to like 6+ years in the feds for having these weapons while he's under a protection order. And then he appeals it. Initially, the Supreme Court in Texas, which is not known for being very liberal, upheld the conviction and was like, yeah, fool, you were out of line, right? But then that Bruen decision happened. Okay. When the Bruen decision happened that we just talked about a minute ago, right? The one out of New York, then he looked at the historical tradition. So this jackass Rahimi turns around and says, well, historically, there was no domestic violence laws in the 17 and 1800s when the Second Amendment was written. So there's no historical context with which to deny me my Second Amendment rights. And the Texas court is kind of like, yeah, we don't really know what to do. And the appellate courts are like, we don't know. We don't even know what to do with this because common sense would tell you that this person should not have a gun, right? But hey, Supreme Court, man, balls in your court, right? No pun intended. So the Supreme Court has agreed to hear that case. And I believe they actually have already heard it, and now we're just waiting for what they're going to decide. So that should be handed down by June 30th of this year, right? Now to the case in the Ninth Circuit. Okay, finally, and we're wrapping up. Appreciate you guys sticking with me. 22 minutes in. Please like, subscribe, leave me a comment, man. Let me know what you guys think of this type of content. I'm gonna be doing more of it. Do I need to speed it up some? Is there more information you guys want? Too much information? Other topics you want me to cover, whether it's legal cases or not. This just happens to be an area that I'm real familiar with and comfortable talking about. But so U.S. versus Duarte, right? Good old Duarte, aka Shorty from Southern California. I was gonna say from Inglewood, but I'm not 100% sure that that's where he's from, right? So Stephen Duarte, this last case he catches though is in Inglewood. So he has a habit of running from the cops. He has a habit of possessing guns. He has a habit of having drugs, and we can see that by his criminal record. He has 5 prior nonviolent felonies in California, right? Vandalism, possession of controlled substance, felon in possession of a firearm, and evading, right? A couple evading police. So he's mobbing around in Inglewood. He's sitting in the back seat of a car, red Infiniti. The front windows are tinted. Cop sees him. Cop gets behind him. They blow a stop sign. Cop hits the lights. Dude tosses the pistol. Cop fucking sees him. They run for like a block. Then, something happens. They get out. They arrest the dude. They look inside the car. They find a clip, right? But no gun. But they saw him throw the gun out the window. So they go where he threw the gun. Clip fits in the gun. Boom. Game over. So the feds pick up that case, right? Give him 51 months, which is actually the low end, but gave him 51 months for the felon in possession of a firearm, right? And for people that don't understand this or don't know, right? Like, why these Fed cases? So California, in the last handful of decades, right, at least, California doesn't really prosecute gun crimes like simple possession and that kind of stuff very harshly, okay? They're not going to do 5 years in prison in California because you got a gun, right? It's a lot of times you just get your gun taken, you go to the police station, you get cited and released, depending on your background. But the feds have much stiffer penalties for gun cases. And so a lot of times the feds will pick up a case from the state, right? Because either they just want to because they don't like you or whatever, um, or because they can punish you more, right? So what's his name? CMAC is an example of that, right? CMAC has multiple state violations, right? But the feds can count all those as priors. And then they have, career criminal laws and all kinds of stuff that add huge amounts of time to your sentence, right? And you can get 15 years for a bullet in the feds, depending on the circumstances. And so that's why it's not necessarily unusual. It doesn't happen all the time, but it's not unusual for the feds sometimes to step in and say, "We want this," and then they go through little cycles where they get extra money to go after certain things, like switches on guns or ghost guns or whatever. And when that's the case, they troll the states all over, trying to grab those cases, to be able to play with their budget. But anyway, so that's his case. Now it's mentioned in here in all the articles about it that uh Stephen Duarte, right, Shorty, is a gang member, is a gang member, is a gang member. And at first I was bothered by this. Like, bro, why even gotta put out there he's a gang member? Because being in a gang is not a crime, right? Being a gang member is actually a constitutional protected activity. The crimes that may be involved with your gang membership are not protected, but your mere status as a member, it is what it is, right? So why do people keep saying this? Is it because he's the Rasa dude that's involved in this? Because they ain't been saying this about other people. Like, what's the catch? And in thinking about it, I realized that's his self-defense claim. Because he says, I carry the gun because I need to protect myself. I need to protect myself because I'm a gang member. Now that's an interesting argument. And I don't know if the Supreme Court is gonna make reference to that or not, right? Not even 100% sure, honestly, if the Supreme Court's gonna hear this case. But I think it's interesting because in state cases, I did a video before on claiming self-defense, right? Gang members cannot claim self-defense. I'll try to link to it at the end of this if I remember. But I did a video about that from a case that I worked in San Francisco. And so, anyways, that's I think why the gang member part keeps coming up. So he gets to 51 months for evading arrest, right, or for a felon in possession. And the Ninth Circuit said that his felonies, if we're looking through the historical lens, those felonies would not have been felonies back in the 1700s, the 1800s, when the Second Amendment, was being argued and then ratified. So they'd be misdemeanors, if anything, right? So historically, he would not have been denied his ability to possess a firearm. Now that was on a 3-judge panel, right, and it was split 2-1. When you go before the Court of Appeals, a lot of times you just go before like 3 judges, and they make their decision because there's a lot of cases going before the Court of Appeals. There's a lot of judges that sit on the panel. These 3 will take this, these 3 will take that, those 3 will take that. But you can request an en-banc review, right? Which basically is like, no, we want all the judges to look at this and then see where the opinion is. Then see if it's still, because it's going to be majority rules either way. But let's get a bigger number in here to see if we get a different verdict. Now, the Ninth Circuit doesn't have to respect that, right? Way back, I believe it was the Heller case that in the appellate court, same thing. It was an en banc review, and they requested the full thing, and the court just said no. Maybe the Chicago one, but anyways, so what they're saying now is they're hopefully they get the en banc review, which they may or may not, but they're not gonna move anywhere on this until Rahimi is decided, right? So they want to see what the court says about Texas. And since the U.S. Supreme Court has already said they're going to say something about the Texas case, now folks are waiting to see what that is. Okay. If the courts agree that Rahimi cannot cannot lose his gun rights from a domestic violence protective order, I think it's a huge stretch for them to say that Duarte can lose his gun rights because of nonviolent felonies. But understand when the Supreme Court makes decisions, it's using the case in front of it to speak about other things. So it could turn around and say Rahimi can't because of these extreme factors, right? But here's the limits. Here's the guidelines if you want to take somebody's firearms, right? Or here's the time span. And those rules that they set up for that may have application to the Duarte case, where they might say, hey, if you have nonviolent felonies, then after 2 years you get your rights back, or you never lose your gun rights, right? Even if you're fighting a case, or even if you're on probation, it doesn't matter. Who knows? It'll be interesting, but we are definitely moving to a place in this country where more people will be allowed to own guns. And now let me give you guys the flip side real quick before I end this. I think this is my last slide. Let me double check. Um, there it is. Like, share, subscribe. There you go. But let me say this, because I haven't always in all these cases told you guys what the other side was saying, right? And it's important, but I wanted to tell you what the verdict was. I don't want to make this an hour-long video, right? But a lot of the arguments against these decisions have basically been, look at all the mass shootings in the United States. Look at all the stuff that's going on, right? And states are trying to regulate guns, and the government, the federal government is trying to regulate that. We have too many firearms. There's too much violence. Da 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 da. And the Supreme Court actually turned around and was like, bro, don't even talk about that. That's not relevant, right? And it talked about the New York case and said, hey, you want to bring up a mass shooting in New York, but these restrictive gun laws didn't change the fact that New York has been having a people shooting at each other problem for a long fucking time. So they're not being distracted by the public policy conversation. And there's going to be some people that are really bothered by that, right? There's going to be others who aren't. But also, like in the New York case especially, right, where they talked about the gun permits, right? And can you show a special reason that you need concealed carry? A ton of support in New York and around the country came from communities of color, right? Non-white, non-conservative communities. Blacks for the Second Amendment, right? The Raza Union, all these different groups. Because they have been arguing that, for example, in New York, that Sullivan law, right? That Sullivan Act has made it to where 95% of non-white people in New York City are not allowed to have any guns for protection. But that's where a lot of the violence happens, and this and that. So this is not a strict Democrat Republican conversation. This is definitely not a conversation that's based just around race. Violence is an issue in a lot of areas of the country, but especially in urban areas, which tend to lean Democratic. And those people in those urban areas, regardless of how they vote and regardless of how much, melanin they have in their skin, they want to be able to protect themselves. And it's hard to argue with that. Right now, a gun is not a shield. A gun doesn't stop you from getting shot, right? But this is not such a. It is a political argument, but there's a large voice in this country. The majority in this country want some greater access to firearms. Right now, what is too far remains to be seen. But the Supreme Court has made pretty clear the direction that they're going. And I don't think we're headed to a place where every adult in America can walk around with anything they want on their hip or in their house. I really don't. The government is going to make sure that they have the ability to restrict people somehow, because there's a lot of money in restriction efforts, right? There's a lot of money in prohibition. And so they're going to make it where some people can't do something. But the Supreme Court is really challenging that. And this historical precedence thing, it'll be interesting if they backtrack. If they're like, maybe we went too far with the historical thing. Like, fool, that's not what I meant, right? But maybe they don't. Maybe they don't. And so I know that I would like to have my gun rights back personally. I don't think everybody should own a gun. I believe in responsible gun ownership. Obviously, I only advocate for legal gun ownership because I don't advocate for criminal activity. But there are people that have made mistakes in life with the law that should not resign them to a lifetime of not being able to protect their home from the tweaker down the street climbing through their window, right? And in particular, when it comes to women, just to be quite honest, right? Which is a group that rarely gets talked about publicly when we talk about guns and gun safety. And there's all this moms against guns and moms against this and moms against that. And that's great, and I'm sure those organizations do a lot of great work. I'm sure they raise a lot of money. But women are the primary victims of domestic violence, of stalkers, of random assaults walking down the street, that kind of stuff. If you're a guy and you're not acting out of pocket and you're just kind of going to the store, you're pretty safe any neighborhood you go to, especially as an adult. If you're a young man and you look like you're in the mix, then the mix might look at you, right? That's how it goes. But for the most part, if you're an adult male, you can kind of move around anywhere. And the odds of somebody jumping out the bushes and, you know, trying to bend you over behind a fence are pretty fucking slim, right? For women, that's not true, right? For women, it's not. And uh, protection orders and that kind of stuff don't always work. They don't provide the security. The cops react to crime. They don't prevent it, And so, and the courts have recognized that. So I think that's the direction that we're going, is less restrictions on firearms. But as of right now, to sum this up, there is nothing you can do. There is no argument to be made for you. There's no paperwork to file. There's no nothing else. For those of us in the general public, all there is to stay tuned. And this summer, we'll have another level of instruction and direction from the U.S. Supreme Court. And is that going to solve all these things or answer all these questions or even answer the question on the Duarte case? Not necessarily. We don't know, right? We don't know what they're going to say till they say it. And so we just got to wait and see, man. But stay tuned. Obviously, I will keep you guys posted. You guys know, man, I do my homework and I give you accurate information. I try to explain things in a homie kind of way, right? Break stuff down. So again, like, share, subscribe, man. I'm doing some different stuff, and I appreciate you guys supporting the process, and let me know if I'm breaking it down right. Moving forward, I'm gonna be careful with my language, not cuss so much. Maybe they play this stuff in school. Anyways, help others move in excellence. That's what homies do. Help yourself at the same time because you're worth it. Help your community because they need you, and stick around, man. I got more content coming. Take care.